Hi. Welcome. Marty, Jerlay, Mom, Tori, everybody who's hanging out, you early birds, I see you. It is December the 22nd, 2025, and this is the Court Gallery. Ladies and gentlemen, welcome to the Court Gallery. Tonight, we're gonna watch three of our favorite judges practically reach the breaking point. And that's saying something when we're talking about Judge Dad, Judge Middleton, and Judge Meyer. That's right, ladies and gentlemen. We're gonna start off with Judge Dad, who has a stepson and a stepfather who are just not seeing eye to eye. There's a lawsuit. And then there's another guy who's made Judge Dad a lot of promises, and man, Judge Dad is really disappointed, and 2 days before Christmas is not the time to be disappointing Judge Dad. And let me tell you, when it comes to Judge Middleton, it's kind of the same way. You know what I mean? After we're done with Judge Middleton, we're gonna tune into Thurston Civil Protection Order calendar, as we do most Mondays. And ladies and gentlemen, as you may know, it did not disappoint. All of that starts right now.
Come on up here, guys. Give me the file. I need the file. John, why don't you move all those? We're gonna have to have them sit there.
You should have.
Huh?
You should have that one.
I got this.
Should have it.
Mount St. Louis versus Brian Marshall, 2502190R. Everybody, state their name.
It's up before Gerard Scanlon, P number 74992, appearing on behalf of the witness Brian Marshall, the president to my right.
Your name, sir?
Morning, Your Honor, Brian Marshall.
Mr. St. Louis, your name?
Donald St. Louis.
All right, let me just look back and file momentarily here. All right. All right. You know what? I hate this I'm filing. I just don't get it. I'm all for change if it makes it better, but it hasn't made it better. It's made it 4 times more complicated. So I don't have a small claims. This was initially filed in small claims, right?
That's correct, Your Honor.
Jennifer, have somebody bring me down the small claims affidavit. Before
Pulling it
then,
up
I
right now.
before then I had files. It was a lot easier. But
Your Honor, if I may.
yeah, you can handle that.
Thank you.
All right, so I've got Mr. St. Louis claiming for labor performed. You're claiming 2789, right? Mr. St. Louis,
He returned my tools after
how much are you claiming?
just the 2,000 plus the court fine
$2,000. What's the $2,000 for?
wages for all the work performed,
Okay,
up to the point of where we had to move to another job because 2 weeks turned into 4 weeks and it wasn't going anywhere because he wasn't.
all right, okay. Sit down, everybody. Give me your opening statement, Mr. St. Louis. You can tell me what your theory of the case is.
We were working on a job on Philly and Allen Park, Carlos, my partner, and myself. For him. He wrote it up and doing the job. He approached us about his girlfriend, homeowner / Lauren. Wanted to have a bathroom redone. So, for the record, he's my stepson, you know. So I went one night, met him at Lauren's house. And she went through the whole procedure of what she wants to do, that she do this, how she'd like to have it done. And I'm like, okay, so when it was all said and done, she went around in another part of the home to water plants, and he said, well, how much are you guys going to charge? I said to do all that work, except he was going to do all the tile work in the bathroom. She's fine. I said 4,800. We had a week to go still, and then when she went on vacation, because it was a 2-week vacation she was taking, I started. The first night, the first time in there, he was in there and I started helping him. And I asked him, I said, what are you doing? Are you taking away work from Carlos and I that you wanted us to do? And he goes, well, I'm just helping you get going. Don't worry, you're going to get all the money. So I continued to go. Carlos would come when he was doing the skin work, the finishing muddy over on another job. So he'd go there for a couple hours, then come over and we'd work together. We completed demo of ripping out all the walls and everything.
All right, I just want to hear what your theory of the case is. He owes you money.
Right.
He owes you $2,000.
I'm being generous on that, Your Honor, because I'm going to go on, just being fair about it. For the amount of time and work I had to put in with him, including using my truck 2 times to go to Home Depot, meet him, load it up with cement, go back to her place, mix it, and all that. He just, for some reason, couldn't stay out of getting it so involved in this, and there was the problem. He was supposed to supply all the materials, we could have been in and out. But it didn't happen. So we put up with it to the point where the other job, Mr. Phillips in Dearborn Heights, had already, we backed him up 1 week, going into totally doing his whole remodeling on kitchen and everything. And finally we had to go 4 weeks. He wanted 2, so you got it done in 2. I said, yes. But at no point were we supposed to deal with him being involved with, he works for major contractor. He ain't even around during the day. And then twice on weekends, he was gone. Once he took his daughter up north to visit the grandpa. Okay, that's fine. But we could not get the material to complete this job. So I figured.
It's your paperwork. That's wise to be.
Good. I figured we normally figure out jobs out at $30 an hour labor. I got at least 80 hours, actually probably more, but I settled for 80. Carlos got 12 coming there. And that there would have been 24 on me and another 340 on him, something like that. So I just went down to 2. That was it.
All right, okay.
The only, but we don't track hours. We bid a job according to what the job is worth on the market. So that's why I said 4,800, but if I had to be reasonable, because they brought it up, wanting to know how many hours, well, we don't track hours, but if I had to give a rough guess, that's where I would put it. To, you know, about 20 some, just over 20, or pardon me, we are 80, about closer to 90 hours 90. But I'll settle it. I mean, simple math.
So you're charging $100 an hour, basically?
No. $30 an hour times 80 hours. That's 2,400.
Okay.
And 12 hours for Carlos when he was there helping me with all, as I submitted into your file, as you instructed to make sure I complete the thing for the court. There's pictures there, but that's not pictures of all the work that was done. I took pictures of a
All
lot.
right, okay. Let me hear from you.
Main premise of this cause of action, Your Honor, is that my client didn't supply the materials for the job.
Did.
Didn't. That's the main premise. Didn't supply the materials. That's what he said. When asked in an interrogatory to describe how the breach occurred, his answer was Brian failed to supply the materials for the job. And I've got receipts that show clearly that my client has spent over $2,000 in materials and he's prepared to testify with it. Further, I've also cited a case in my trial brief. This is the Van Dyke's case that indicates that when a job is done for a family member, which Mr. St. Louis has already testified that my client is the stepson, it's done for and gratuitously done and or furnished. In that, there's a presumption that arises that Mr. St. Louis is going to have to overcome according to the case law. He has no cause of action. He has no damages. My client supplied the materials, and thus we're asking that the case be dismissed and costs and attorney fees be awarded.
We did some work, though. Nobody's disputing you did work, are they?
That's not the nature of the breach. The nature of the breach is, according to him, in his own words, in the interrogatories that I'm going to introduce as evidence, the nature of the breach is that he failed to supply the materials. My client has received from Home Depot indicating that the materials were purchased and he's prepared to testify that he did purchase them.
All right.
Therefore, he has no cause of action.
Call your first witness. Call your first witness. If you want to testify, you can come up here. If you don't, you can call your friend here, or you can call the defendant here, or call whoever you want. But you got to come up and I'm going to swear you to an oath. That was just an opening statement before. Yep. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole truth self you got. Have a seat. All right, go ahead and tell me. Now you can be detailed. Go ahead. Tell me everything you want to tell me.
When I went in there, they had already been doing shopping. A toilet somewhere. It was worth $1,000.
Are you charging for the labor or for the materials?
Just the labor. The agreement was he's gonna supply the material when I needed it. Not purchasing a cabinet here, a toilet that was all done before we even started. I mean, going in, they had stuff stockpiling. So if this material for receipts is where he's going, the only materials he bought while I was there working was copper, piping, fittings, shutoffs, the PVC 3-inch, 2-inch, and 1.5 inches for the drain systems. There was some lumber.
Sir, I'm asking you, are you suing for labor or materials or a combination thereof?
Just labor, sir, Your Honor.
Just labor.
Here, that's all, Your Honor.
All right. And how many hours labor did you have?
I'm saying I can safely say I put it at minimum 20 hours labor. We charge $30 an hour labor. That's a very good rate in this kind of.
Okay. That's $600. How are you coming up with 2,000?
80 hours
You
times.
said 20 hours.
Oh, I'm sorry. I'm wrong. 80 hours, 2 weeks. I was there for over a 4-week stretch, in the evening and on weekends.
And what did you do in that 80 hours?
We finished
I'm sorry?
demoing all the old walls and everything. Then I had to remove piping. And there was 2 exterior walls when we come in. I ended up removing them. Copper. Then I was doing rerouting copper for where it was supposed to go. The whole drain system. He cut the floor out because he was.
I want to know what you did. Don't talk about him.
Yeah.
What else?
Then I was there in the evenings helping him like I said.
What were you doing?
People got cement, come back, mixing cement, he took it in and doing that.
What else?
The wire, moved couldn't move all of it. Some
Demoed the walls, removed the piping,
repair and.
rerouted the carpet, and you went over and got cement for him. That take 80 hours to do all that?
Oh, yes.
80 hours to do all that?
Yes, you're right.
Okay, what else? Anything else?
Because there,
I just want to know what else you did.
there's a lot. I should.
I want to know. Tell me.
So the walls that I removed were the existing old walls. Okay, and then I chipped around to give them an idea of where the plumbing had to run. I had to retake apart, this is it, even going to do stuff in the evening. And then the next day I gotta clean up when
I want to know what you did. Just tell me what you did. I don't want to know what he did. I want to know what you did.
And I loaded the trailer and hauled it to the dump, emptied it and brought it back, which I even paid the dumping fee. Which that was out of my own pocket. So all this work that I put in time putting in on this job, and many other times it was cleanup after him leaving a mess all over. That was it.
And he tell you he was going to pay you $30 an hour.
No, he agreed to pay 48 for the job, but we were
48 what?
$4,800 for the whole job. Then,
But you never got that in writing.
no, we had a verbal agreement and when he even discussed it with, talked to Carlos about working over there too.
All right, go ahead.
So basically, we're just asking for the amount of work we did came to almost half of the work that was supposed to be put in, not counting Kyle's.
All right.
That was his understanding and agreement.
Okay, fair enough. You got questions for him, Mr. Scanlon?
You, St. Louis, you indicated that you don't have anything to prove that this conversation between you and my client took place, correct? Regarding,
At the
regarding,
house or
No.
at the Fillmore?
you don't have any proof regarding the conversation that took place that indicated that my client was going to pay you $4,800 for this job. Nothing in writing.
Nothing in writing, no.
Okay, and you indicated that you don't have anything in writing to prove that my client offered to pay you $30 an hour for labor performed on this job.
No, he wanted the ballpark price for the job, which I quoted 4,800.
Your Honor, can I approach the witness?
Yes. Did you work with your stepson on work before?
Yes, we were coming off, back there, we were coming off of a house in Allen Park, Philomene. We opened up the kitchen, removed walls, redone it. I moved, electrical, plumbing. Actually, I did a lot of electrical for it. We had no written agreement. It was a verbal agreement on that one too, which
All right, okay. I just asked you if you'd worked with him before. That's good. You answered the question. You can proceed.
I'm gonna approach the witness, Your Honor, and show him what's been marked as proposed exhibit, defense proposed exhibit.
Hey, sorry. Sir, do you recognize that document?
Did you just mark that yourself?
I did, unless you're a sticker.
Yeah, we're gonna mark it defense one. Hand that back to my recorder, will you, Mr. Scanlon, please?
Defense one.
Yes.
Recognize that document, sir?
whole thing,
Yeah. I'll give you some time to look through it.
question. We have any local. I'm reading, it was more about supplying material. He kept,
I didn't hear a word you said, sir.
I'm sorry,
There's no question. I just asked if you recognize the document, sir, yes or no?
yes, I do.
Okay. How do you recognize that document?
Well, you sent it to me.
Okay, and these are interrogatories that were sent to you by my firm. I'd like to draw your attention. Question number 5. You can turn to that one, please.
Yeah, I got it right there.
Says, please describe in detail how the verbal agreement between you and the defendant was breached. Can you read for me your answer, please?
Brian failed to supply all material for us and continued to disrupt the work that Carlos and myself agreed to do from an agreement we made.
Okay. So that answer indicates that my client, the breach of the contract occurred because my client failed to supply the material, does it not?
Well, there was more than just that.
So yes or no question, sir? That
That was
was
part of it.
Well,
Yes or
yeah,
no?
that was the answer you gave though, right?
Yes.
Okay.
Well, there you have it.
I know. What else, Mr. Scanlon? I mean, this is pretty easy. I want to hear from your client.
Understood, Your Honor. I just want to put the proofs on the
All
record.
right, go ahead. Ask me your next question.
Question number 5. I'm going to ask you to produce a copy of any invoice that you sent to my client for any outstanding balances. You didn't send him any outstanding invoices, did you, sir?
No, I wasn't buying anything.
All right.
But you never sent him any outstanding balances for any materials, and you never sent him any outstanding balances for the labor work, right? Yes or no?
There is no balance for material. I was not responsible for purchasing it. So why would I send it?
It's not a question.
I don't need you to argue with him, but I got his answer. Move on to your next question.
And you indicated, sir, that Mr. Marshall is your stepson?
That's correct.
I have nothing further for this witness at this time, Your Honor.
Do you have any other testimony you want to offer? Yes or no? No. Okay, I want to hear from Mr. Marshall. Come on up here, Mr. Marshall.
Sorry, I moved to admit this.
Yeah, you can move to admit that. That's defense one, right?
That's the offense was even.
Any objection to the admission of that, Mr. Your Honor? Defense one is admitted. Mr. Marshall, come on up here. Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you give in these proceedings will be the whole true self you got. Have a seat.
Your Honor,
Wait,
I do believe that what he just admitted, I already gave you a copy in the file as part of it.
it's fine. Did you hire him to do some work for you?
I did request, or if they'd be willing
I
to.
can't hear you. Keep your voice up. Did you hire your stepfather to do work for you?
I requested assistance for him.
Did you pay him?
I did not pay him. He was under he was gonna help me with my girlfriend's bathroom.
Did you pay him on the prior job that he had just described that he helped you with?
I did, Your Honor. That was through my construction company.
But you didn't pay him on this one.
Correct.
Did you ever stop him from going over there?
I would never stop him from going over.
Did you ever tell him, I'm not paying you for this?
I mentioned it on a text message when he called and said I owe him money for work he performed. I told him that I was gonna, it was the, if I may, Your Honor, the bathroom was for my girlfriend. It was boyfriend helping
I
girlfriend.
know, it was your girlfriend, not his,
Right, not his girlfriend.
right? Wait, wait. I want to ask you some questions here, and I get it. Do you have any reason to dispute that he worked on that bathroom?
No.
You heard how many hours he said he worked. He said he worked 80 hours. Do you have any reason to dispute that?
That
How many hours do you think he spent working over there?
realistic work is probably 10.
10 hours?
10, if you, I'll give him 20.
Did he demo the walls?
I assisted in demoing, yeah.
I didn't ask you that.
Yes.
Did he demo the walls? Did he remove the pipe?
Yes.
Did he reroute the copper?
No,
Did he go and get supplies from time to time?
he assisted me, but
He got cement, right?
in his truck with my.
And he brought it back there, right?
Correct.
And was your girlfriend home the whole time?
No,
Were you there every time that he was working there? How did he gain access if you weren't there and the girlfriend wasn't there?
he had a key provided by my girlfriend.
Is $30 an hour a normal price for that work?
Yeah, that's a fair price.
But you expected him to give it to you, do this work for free?
It was a team effort. Carlos was gonna be the gentleman who came in and did.
I know, but he wasn't the girlfriend, right? I mean, you were doing this for your girlfriend, right?
Correct.
Was he friends with your girlfriend?
Yes,
Was he friends with your girlfriend before he started working on the job?
yes. He's known her for a long time.
How long's a long time?
Maybe my girlfriend and I have been together for 8 years.
How sad. You guys are father-in-laws. I mean, stepfather and stepson, and you guys are in here and,
I agree.
huh?
I agree.
Well, I know, but I don't think you've been fair with him. You want my honest opinion? I don't think you've been fair with him. You better make it 100% certain, 100% clear that you're not paying him. If you're going to have him do work, I don't care if it's on your girlfriend's, I don't care whose house it is, your friends, I don't care. Do you have any questions of him?
Mr. Marshall, you indicated that the amount of work that was done by Mr. Singh was amounted to maybe 20 hours. Correct. Not the 80 that he's indicated. Correct. And you did in fact pay for labor or materials rather, from Home Depot. That's right. Okay. And you had those on your credit card statements?
Correct, the Home Depot credit card statements.
No, very close to witness.
Yeah, sure. I don't care what he answered on the interrogatories. But did he say or not say that he wasn't seeking any amounts for materials?
It's the basis of his lawsuit.
Well, I don't think so. It sounds to me like it's more labor. Are you not suing for the labor?
Labor only, Your Honor, time put in. For work done.
Even his affidavit, money's owing for labor performed at 23776 Carter Road, Brownstown.
Right.
I don't care what he said in an interrogatory. He's not a lawyer. He did a half-hazard job. I'm not even considering materials here. I'm not awarding him anything for materials. So I don't think we got to talk about materials because it's not relevant. Unless we get into the 4,800 and you want to start talking about that. 4,800 included materials, and so this guy, Mr. Marshall, bought some of the materials, so that should rightfully come off the contract price. But I'm just telling you how I'm leaning here, and that is this guy's entitled to quantum Maryland. Whether they had a ironclad solid agreement or not, $30 in the industry is not outrageous. He clearly did some work. The question is how much work, and it has nothing to do with the materials. But go ahead, you ask, and I'll rule, and I'll stop you if I think you're going off into places that are.
Well, and I would argue, Your Honor, too, that he answered these interrogatories and indicated that the breach occurred because materials weren't paid for. Regardless of
The
whether.
first word of his claim is for labor performed.
Right.
Look at his affidavit and claim.
So what's the basis?
Hang on, I want you to look at his affidavit.
I did. What's his basis?
He said money's owing for labor performed. Why are you arguing with? I mean, I could read this when I was 6. Money's owing for labor performed. He doesn't say anything about repairs. I'm sorry, it doesn't say anything about materials.
So he's indicating that there's labor, yet when he answers the interrogatory.
I know, I get it. That can go to his credibility. I get it, but that's what his claim's for. And I heard everything you said, that he indicated that this gentleman didn't supply him with the materials. I get it. But I don't think he's really talked about materials. He talked about picking up materials maybe that Mr. Marshall should have picked up. Go ahead, ask your next question.
No, that's fine. I'll rest.
No, I don't, listen, I'm not trying to talk. This is a very small case. And I want to afford you every opportunity to ask whatever you want. I'm just telling you where I'm going with that. And that's what I'm going to do on these little cases. That's what I always do. And so we don't have to guess. This isn't over 25,000 or anything more, but go ahead, let's. All right,
That's what it was.
do you have any questions of him?
I do, Your Honor.
Go ahead.
Finished on that Sunday. And you stormed out because you wanted to run wiring and I'm like, upset of you. Now, after that day, I called you and I said, I need the rest of my tools.
Is this a question or a
I
testimony?
wanted to verify that this is what I asked you for money owing. What was your response to that?
You asked if I had your planer.
No, about the money. When I said you owe me $2,000, what was your response?
I don't know you when you walked off the job.
You said you don't have to pay me because we didn't have a written contract. Is that correct?
I don't know. Exactly. I gave her the text message, so.
When I told you that night how much money that Carlos and I would expect to do everything, and you were only gonna handle tile work at the end, did you inform Lauren about that?
Lauren was present during the conversation.
She was not present when I told you the amount of money. There was only you and I.
All right, you can't argue with him.
Yes.
You can come back up on rebuttal and tell me something different, but you can't argue with him. He's not giving you the answer you want.
Did
but-
the homeowner know that the amount of money we wanted?
Lauren was present there.
Chad calls for speculation.
That's fair. I'm gonna sustain. Strike that answer. Go ahead and ask your next question.
That's it, Your Honor.
You can step down, sir, unless you have something else.
Okay.
Come on back. I want to hear from you. Is this your buddy here?
This is Carlos Velazquez. Him and I have been teamed up for 27 years working together.
Come on up here. Can you spell your name for my recorder?
V as in Victor, ELASQUEZ.
Raise your right hand. You solemnly swear or affirm under penalties of perjury, the testimony you give in these proceedings will be the whole true self you got. Have a seat. You know which residents they're talking about.
What's that?
You know which residents they're talking about.
48 minutes. That's the city that Brian's girlfriend lives in.
Did you do work there?
Yes.
How much work did you do?
Help Brown doing the plumbing.
I didn't ask you that. How much work? How many hours? What did you do?
I assisted Brian with plumbing and doing a couple framings and walls. Right by the backside of the shower. I was at another job, in between jobs, and while letting stuff dry over there, I would come and help Ron a little bit. That's how we work. So he would do the plumbing, electrical to get started, then I would come over there, then we would do the drywall, I would finish all the drywall, then we will assemble everything, because, you know, it's a step-by-step process, doing things like that.
Do you have any questions of him?
No, Your Honor.
Do you have any questions of him?
Well, how much time did you spend on this job?
About 14 hours.
That's it?
Yes. We was in the middle of another job. I was finishing the other job.
Were you
In the
there,
process, I would go over and help him with a few things.
were you there the entire time that Mr. St. Louis was there?
I was not.
So you have no way of saying how much hours Mr. St. Louis spent on this job?
The way the job works, it's not,
Yes,
it's
sir.
like a small puzzle.
Right.
So, no, I wasn't there the full time.
So you don't have any idea how many hours Mr. St. Louis?
Just basically from what he told me every single day, call.
Okay, thank you.
I'm sorry, I didn't hear that.
Basically, every day he would call me. And he would tell me, you know, what he did. It just, you know,
Any other questions of him? Either one of you?
All right.
You can step down, sir. Thank you.
thank you.
Do you have any other witnesses, Mr. St. Louis?
No, Your Honor.
Do you have any witnesses, Mr. Scanlon?
No, Your Honor.
Any argument, Mr. St. Louis?
I don't know if Your Honor has had a chance to look at all the pictures that I put in the file for the court when I filed it here. The response from his attorney.
I don't look at photographs and documents like that unless they're admitted into evidence. Is there something you wanted to admit into evidence that you wanted me to look at?
Enter all these as evidence,
What are those?
pictures of work that was performed.
How many pictures you have? How many? More than 5?
Oh, yes, more than 20.
I mean, I can have them marked if you want. Mr. Scanlon, any objection to me just marking all of those pictures as plaintiffs in one? You gotta lay a foundation. I mean,
There's no foundation for them and they weren't produced prior to, the court had a scheduling order in this case. He was supposed to produce those prior to, he didn't. So I would completely object to that. It's inappropriate.
Your Honor, that form that he showed you with all the questions that I answered, I also turned in an envelope inside that vanilla that had pictures exactly of what you have here. Was turned in at his.
all right, okay. Give me the pictures. Hand up the pictures. How many pictures you got? 20? Why don't I
Oh, do I give it to you, sir?
oh, you tell me how many pictures you have there. Let me see. Mr. Scanlon, I could let him come back up here. I mean, what's fair is fair.
I'm sorry. Who you're on?
I'm gonna just have these marked 1. You saw all these pictures, right?
No, I have not.
You've not seen these?
No.
It's roughly 20 pictures here.
175, because you don't have it, it's in the.
I'll let you take a look at these. And my inclination is to have the first picture marked plaintiffs 1. Mark outside on an envelope plaintiffs 1 and put all these pictures in here. Take a look at those. You're still under oath a second here. Do these pictures demonstrate all the work you performed at this residence?
No, they do not, Your Honor. There is some in there where early pictures of where I was rerouting copper, and then I should have taken pictures at the last day of finished the copper run.
But all the pictures there, do they reflect work that you yourself did personally?
They do, Your Honor, except the removal of the concrete.
Do you want to have me mark those?
No, not at all. I don't even know. He just established a foundation for that.
Man, okay, hand them back. I'm not gonna admit those. I'm gonna listen to you both argue. Tell me, what would you like to say?
Pardon me, Your Honor.
I'm gonna have you guys argue your closing arguments. Nobody else has any witnesses, right, Mr. Scanlon? Mr. Scanlon, you don't have any other witnesses, right?
No, I don't.
Go ahead.
I have no other witnesses either, Your Honor.
I know, I want to hear what argument. You want to make an argument? You don't have to.
No, other than the fact that the work was performed, his evaluation, I can understand why he wants to load all hours, but just on the cement work for 2 times this, 10 hours of my time there.
Okay. What do you have to say, Mr. Scanlon?
Burden of proof is on the plaintiff, Your Honor, to prove his case. He has the burden to produce evidence to show the court, to show the court how many hours he's actually worked. We have no testimony from any witness that would reflect that he actually performed 80 hours of work on this property. His own friend, Carlos, didn't even testify that he was there with him at the time the job was being performed. So he couldn't even verify how many hours were actually performed on this particular property. This was an unfortunate job, where, you have 2 individuals, a stepson and a stepfather, that are fighting over a verbal agreement. No evidence of the agreement, no evidence of anything in writing, no evidence that my client indicated that he was going to pay him. I ask that this case be dismissed.
Thank you. Anything else, Mr. St. Louis?
Yes, Your Honor, if there is no agreement, why would he tell me on the phone when I had a request payment, he didn't have to pay me because we didn't.
I don't want to hear anymore.
No,
I don't want to hear anymore.
yeah.
if you were not going to pay him, it was incumbent upon you, Mr. Marshall, to fully and completely let him know that, especially if you'd come off another job. This wasn't like you went to him. I heard no testimony. You went to him and said, hey, listen, you know, Susie or whatever her name is, we've been going out 8 years. We're all close. I'd appreciate it if you do me a break on this, give me a break on this and help her out and not charge her or not charge her through me or make me eat the price of this because you're helping me. And I've got to pay you. I heard nothing like that. And I got to tell you, whether I admitted those pictures or not, based on what he told me, and I'm no construction guy, sounds like a lot of work. I have no reason to disbelieve his testimony. Judgment for plaintiff, $2,000 plus the 88 filing fee. And if you have any other fees, you have a motion fee, I believe $20, maybe not. What other judgment or fees does he have here, Jen? You have any other out of court?
Judge, I think that's it.
I think that might be defendant's motion filing fee.
It was
So
defendant's motion.
yes, so I'm gonna make it 2,088. Can you pay this today, sir? When can you pay this? Okay. If there's a way you can go get it today and write him a check, I can do a stipulated dismissal. If you can't, I have to do a judgment.
I can get a check.
Today,
I can make it happen.
can you get it here in the next half an hour? Yeah, you good with coming back in an hour?
I am here.
The quicker the better. Mr. Scanlon, will you prepare a stipulated order for dismissal with prejudice? And then I'm gonna wait here. I'm not gonna go anywhere. And my staff's not gonna be able to go anywhere. So I'm gonna ask you to go hustle on this and we'll go from there, okay? And then we'll do a stipulated order to dismiss with prejudice once he tenders the check. Okay, thank you. I'm gonna need Jonathan Patrick Johnson, and that's Emily on that one, 25B1489318.
Jonathan Johnson.
Name, sir?
Johnson.
Okay. What are we doing on this one?
Both applications, number 5 and number 7 are duplicates. They're the exact same thing, same date and time. But he was pleading guilty to the violations. It's a combination of positives for alcohol and for mis-sobriety tests.
If you plead guilty, so I'll just dismiss count 7. Is that fair?
That's fine.
So he's gonna plead to 1 through 6 and 8 through 12.
Yes.
If you plead guilty here, sir, your probation could be revoked. You could be incarcerated for up to 93 days. Do you understand that? I can't hear you.
Sorry.
Did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights. And there will not be a hearing. Do you understand that? I got to keep your voice up for me, sir. Did you hear what I said?
Yes, sir.
You got to keep your voice up for me. You understand everything I've said? As to count 1 that you failed. Just give me 1 second. Failed to submit to 7 a.m. PBT on December 12 of 25. How do you plead?
Guilty.
And that's on the sober link, and that was on December 12, right?
Yes, sir.
Did you fail to do that?
Yes, sir.
Count 2 that you submitted a breath test through a sober link on December 13th with positive results. So that would be failing to refrain from consuming alcohol. How do you plead? Did you fail to refrain from consuming alcohol on the 13th?
Yes, sir.
Count 3 that you failed to refrain from consuming alcohol, testing positive again on December 14th. How do you plead? Did you consume alcohol, say again on that date?
It was within 72 hours.
I didn't ask you that. Did you test positive for that and consume alcohol on the 14th?
Positive, yes.
Count 4 to the charge of failed to refrain from consuming alcohol, submitting to a breath test with positive results on December 15th. How do you plead?
Guilty.
Did you test positive that date?
Yes.
Count 5 that you failed to submit to a 7 a.m. PBT on SoberLink on December 18th. How do you plead? I need Emily in here on this one. Count 6, that you fail to refrain from consuming alcohol, having a positive result on December 16th. How do you plead? Count 8, that you fail to submit to a PBT on December 18th. How do you plead? Count 9, did you fail to do that? Yes? Count 9, that you fail to submit to a 7 a.m. PBT on December 20. How do you plead? Fail to do that? Count 10, that you fail to refrain from consuming alcohol, testing positive on December 20. How do you plead? Fail to do that? Count 11, you failed to submit to 7 a.m. PBT on SoberLink on December 21. How do you plead? Fail to do that? Count 12, that you failed to refrain from consuming alcohol, testing positive for alcohol on those dates in time, that date, December 21, at 9:04, 9:18, 9:48, October 18, October 48, 10:48, 11:31, and then missed on 11:48. How do you plead?
Yes, guilty.
Did you fail to do that?
Yes.
Anybody force you to plead guilty? Pleas are accepted. The counts 1 through 12, with the exception of 7. Count 7 is dismissed. It's a duplicate. I think I need Ms. Tessino to tell you what's going on in this. Your name?
Alexina,
How disappointing. What would you like to say? I want you to tell Mr. Haynes from the beginning what has happened on this.
So he is scheduled for sentencing on 2 separate show causes on January 14th. There were similar issues, and he was saying that there was something wrong with the device. So we got him a new device, and they sent his other device out to have it checked if there's anything wrong with it. And then got the new device, and we're happy.
So either he should go play the lottery, because I don't remember having somebody have a malfunctioning device of any kind. Maybe there was. But for someone to have 2, 1 ticket, 150 million. I can't wait to hear, because I am really upset with Mr. Johnson. He gets in sobriety court. We told him it was a marathon. He didn't even get to the end of the sidewalk up here, and he's basically quit. Go ahead. I want to hear.
Yes, Judge, and I don't have the particulars on the hearing that's coming up, but in talking to Mr. Johnson, he's been pretty direct and candid. He's struggling to dock off.
He lied to me under oath. He lied to me under oath. I want to repeat what I said. He lied to me under oath. I gave him every opportunity to come clean, and you lied to me under oath. You got no business being in sobriety court. We made a massive mistake on this one. What a failure on our part to see through the nonsensical garbage. And I, as the head of this sobriety court, accept full responsibility. You lied to me under oath. You don't lie in a courtroom, son. I don't care what it is. You want to tell me I'm struggling? I'd have been so understanding, it wouldn't have even been funny. You don't lie to the judge, and you don't lie when you're under oath, and you hit both. I feel like terminating him right now. That's how upset I am with him. I really do. I mean, I'm just ready to go give him 93 days and let's move on. I will not tolerate people lying to the courthouse, not me. It's not about me. Not about me. You don't lie to the judicial system under oath. You don't do it. I gave him every opportunity to get off the mat. No. It's a malfunction. It's a malfunction. So I got to have people from house arrest take time from their day to come on. We got to fool around with switching out devices. And then the same thing happens. And I'm telling you, if this was a malfunctioning device, not one, but two, he needs to go buy a lottery ticket. He'll be a billionaire by 6 o'clock or whenever the next drawing is. Unless you think I shouldn't terminate him, I'm doing it right now.
Did he plead guilty?
Yeah, he's pled guilty to all these. And now his lawyer started out, Mr. Haynes, a gentleman, he's struggling with alcohol, which is what I knew from the beginning. But he wouldn't tell me that. He wanted to lie to me. He wanted to assure me he didn't. I told him, you're not going to testify falsely under oath. Go ahead.
Judge, you've been around this even a little longer than I have with this a long time. With this particular problem, you don't know when people are ready. You don't know when they admit it. You don't know when they see the light. A lot of times people have done a long time trying to get away with things and it becomes a habit. Today, and this is not a rant for the other part of this, I met Mr. Johnson for the first time today. We talked about it and pretty quickly we got to the point. He has been involved in counseling with the GERA. I'm hoping the court will order that his counseling is increased, possibly intensive outpatient, because he is struggling with that degree and he needs the help. I don't know exactly what's going on with him in his personal life, but he does have a job. He works at the call center, gets off at midnight. He says he's doing his meetings after that. He's working toward getting a sponsor, but he doesn't have one yet. And maybe getting a sponsor would be the part of this that helps make a difference for him. But if he's made a step today that he's acknowledging this, I hope he gets a chance.
Anything else that you want to say, sir?
No. Give me this option. I won't fail. I don't want fair people.
Anything you want to say?
I'm sorry, I am with Mr. Hayes in some capacity that I don't think it's uncommon for the early days for people to fight it. I think it is a step in the direction that he was at least honest today. I'm equally as frustrated when I think of the work I put into the other violation. I'm kind of thinking that maybe a scram tether would be appropriate because now we're having an issue that he's missing the 7 and 11 a.m. one. And then I would definitely want to speak to Higuera about getting him into IOP and maybe an MAT consultation. And the ETG did come back and confirm I got it today for the record.
I just don't understand. I just don't understand how when a judge lets you off the mat, and I did let you off the mat, I mean, I told you not to lie to me, and you lied under oath. I get the whole addiction thing. We all get that. Every one of us get that. I don't understand how when I was talking to you and I knew you were lying and you kept assuring me you weren't lying and you testified under oath, I would not blame myself for sending you away today for 93 days. I want to be clear about that. You just got started in this program. And you aren't even giving it a shot. And again, I get the addiction thing. We all understand that people are going to fail. They're going to relapse. I get it. But you went to such great lengths. I'm going to have a hard time forgiving you for that. I mean, you really went to great lengths. But that being said, here's what I'm doing. You're to serve 10 days jail now. I don't care who you're going to be with or not with on Christmas. That's just too bad. That's just too bad. You're going to serve Christmas Day in jail. And for you to make me do that, for me to do that, you really pushed me. You ought to know that. You're to have a MAT consultation. You're to convert to a scram tether first business day following release. So we can even take the sober link that he's on. I don't know where he got it, if he got it from house arrest. Pardon?
He'll have to take it to house, if he doesn't have it with him today, he can bring.
Do you have it?
I would rather him keep it almost, so that when he gets out.
It's going to be,
What if he gets out at 7 PM on a Saturday,
that's fine. I'll let you work on that. You're going to return that. We're going to give you a scram tether, 10 days jail, 21 days to appeal, 15 days to apply for a court-appointed lawyer for purposes of appeal. This is basically, there's no basically about it. This is your last chance. You lie to me again, and we're done. Good luck. That's what we'll do. And you can talk to Gary about IOP, intensifying the treatment.
Sentencing for the court.
I do. And we'll see how things go. Thank you very much.
But we are ready to address People versus Daniel Gary. Mr. Gary, why don't you come up and have a seat with your attorney, Mr. George?
I just slipped in the shower, put some rope in it.
All right, well, I'm sorry to hear that. I'm a little crooked today myself.
Yeah, I don't, at 55, I don't know how many more falls it's gonna take before I say no. Like my mom, she's almost 80, and she still does not say no, I'm fragile. She usually lift boulders like that, landscaping her.
All right, well, give me a minute to get caught up here. This is file 251979SM, People versus Daniel Gary. Mr. Gary is here with his lawyer, Mr. Tim George. Mr. George has represented Mr. Gary in the past and has had a good attorney-client relationship with him. This matter was charged with domestic violence and interfering with a crime report for an incident that occurred on August 6th. The matter was set for a pretrial conference, then was actually set for jury trial. The defendant entered a plea to disturbing the peace. That plea was entered on December 10th. The other charges were dismissed. Disturbing the peace is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. I left in place a no contact provision with Ashley Brown, who was the complainant in this case. Mr. Gary had a previous disturbing the peace that he had been delinquent in his payments. So I adjourned the matter for a couple reasons. I wanted to have a no contact provision remain in place, and I wanted to see whether Mr. Gary continued to pay on his fines and costs.
Yeah, they should be all paid.
Well, I reviewed this morning, you made an October payment, you made a November payment, and you made a December payment. The last payment I saw was December 3rd. There's something more than that. So he was paying on his earlier disturbing the peace. He did spend 2 days in jail in this matter before he was released on a PR bond. I was troubled. Mr. Gary had continued to have contact with Miss Brown, I think through the period up to the plea. So I entered the plea. Mr. Gary then walked out of the courtroom, went outside and called Miss Brown for a ride. And the bailiff said, "You can't do that," and gave him a bus pass. So I haven't heard anything since, but
that lady officer told her not to come. She was giving me the bus.
Well, true. It was like 1 minute later, you went out and did exactly what I told you not to do. Now, I do know that you suffer from autism. I don't suffer, you deal with it. You've been dealing with it your whole life. And you're on the spectrum. You also have some other mental health issues that you've been trying to address.
Yeah, in jail, you don't get your medication, so I mean, it's gonna be really, I mean.
So this was reduced to a disturbing the peace, which is normally a fines and costs circumstance. Mr. George, what would you like me to know?
Thank you, Your Honor. And I know that the court has concerns, and I think the prosecutor had relayed those as well regarding some of the contact that had taken place. I think from Mr. Gary's standpoint, he's concerned that if there was any jail time that was imposed, that he wouldn't have the ability to access his medications that he takes. I think for him, at least in the last few conversations we had, his biggest.
Just a minute, Mr. Gary, we'll give you a chance to speak. I think
he's focused on trying to get things together as best he possibly can to get out of here, get the house sold, and move on. And maybe that wouldn't be a bad thing to change his scenery. I think if the court were, considering some alternative sentence other than the fines and costs, we would ask for a probation instead of the jail time. That would allow the court to continue supervision. If there were any type of services that the court think that Mr. Gary could engage in, that would help alleviate some of those concerns. Those could be done over the course of that probation. But I think the biggest articulated reason for it would be continued supervision from the court to make sure that any orders of this court would be followed. Thank you.
Ms. Canfield, do we have any updated information from Ms. Brown?
Yes, Your Honor. My office has had continual contact with Ms. Brown on the date of the plea, which confirms the information that we all suspected. He'd been living in the home the entire time this case was pending, having contact with her on a daily basis, including on the day that she authored the victim impact statement to this court. That's extremely concerning to me because that's obviously not done of her own free will or done in a setting where she felt safe to communicate with our officer, the court.
The
first time that
she's right here in the building. She can talk to her right now.
I'll give you a chance
She's in
to
the building
speak.
right now.
She's in the building, you
Yeah,
said?
she has to take care of because the paperwork and she got notarized
All right,
correct
so-
right now.
Just a minute. Is she here in the building?
Sure, you have to take care of her so we can get this house sold and get out of it. You'll move on.
Yes.
I think she's at the.
At least a couple hours away, you know?
All right, would we see if we can find her?
Yeah, she's right up there.
Her name is Ashley Brown. She may be at the Register of Deeds. All right, Ms. Canfield.
Thank you, Your Honor. And what's more concerning also is that this isn't the defendant's first contact with the court. It's not as if he hasn't been in trouble before and understands the court's orders. He was on probation for drunk driving in 2016. He had a use of narcotics and an attempted resisting and obstructing in 2019, for which he received 90 days in jail. And then he damaged a traffic device and pled guilty to that in 2023. Now we're here in an incident where, yes, it was resolved with a disturbing the peace, but it was because her phone was grabbed out of her hand and she was headbutted by the defendant, and neighbors were involved in seeing this occur. So in this particular instance, he also was to have no contact. He's violated that the entire time the case is pending, inclusive of the day of the plea when the court specifically instructed him, do not have contact with Ashley Brown. And then you go out and use a
I get the
court.
statement, because she's staying somewhere else. I'm new here.
All right, just a
You know, I
minute.
have nowhere to go. She
Daniel,
had to get gone.
I'll
I
give you a
stayed at the house.
chance. I'll give you a chance to
So
speak.
she came over on her free will, you know, she knew better. She
All right,
had, she had.
all right, Daniel, just wait.
Okay, sorry, sir.
All right.
Thank you, Your Honor. He just repetitively violated this court's order, specifically after the court
I own
told
the
him
house.
not to, and he went and used the security phone to call the victim.
Yeah, because she took off with
Stop,
it, and
stop.
she owed me $300 for gas, I mean, for
all right.
water bill. And she goes and spends it all with Josh Brown.
Your Honor,
Alright.
so
They come back, yeah,
Clearly.
and with my
Alright.
cell phone.
All right,
It's my cell phone. I was the one with 2 hours without it, them 2 hours, they're counting on my phone.
all right, Daniel,
All right.
calm down.
there is not a circumstance
She's right here, she'll verify that shit.
All right,
in which she is safe, given the emotional status of the defendant.
Yeah,
Yeah, just 15.5 years in
All right.
Westville.
all right.
See how you feel. Okay?
Put Mr. Gary back in the lockup.
Yeah, please. I need a break.
Yes, we may give you a break till about Valentine's Day. I want you to go back there and calm down.
Brother.
And Your Honor, I understand the defendant has mental health diagnoses, but we also have to make sure that the public and Ms. Brown are safe in addition to the defendant not being a risk to himself.
I'd like to hear
I am
from
gonna
her.
request a jail sentence.
It's always a problem when we take a plea to a reduced charge and then ask for a maximum sentence on the reduced charge rather than the larger charges. But I don't know what side of the fence Miss Brown is on, so I'd like to hear from her. But he's gonna talk himself into about a 30-day jail sentence. So we'll see if he calms down a little bit, and then we'll wait for her.
There was an impact statement submitted from Ms. Brown requesting jail, Your Honor.
I did review it. All right. Mr. George makes a good point. When he goes to jail, they tend to not give him his medication. And then that causes further issues, but they're doing a better job than they have been in the past. Mr. George, if you'd wait for a minute, we'll see if we can find the complainant and we'll take up Mr. Truckey's case.
Yes, sir.
Apparently we didn't find Miss Brown.
No, I was able to make contact with her
Okay.
on the phone. She said that she was not able to come in and speak.
Does she wish to continue the no contact?
Yes.
Okay.
When I spoke to her on the phone, she indicated that she thought jail time would be appropriate, and she made reference to the letter that she mailed me, I believe, on her phone.
All right. Well, you couldn't, that's on the record, sort of. The defendant wasn't here, but that's input from the victim advocate, Kendra Ackerman from the prosecutor's office, and we'll repeat that when he comes in the courtroom. As for Mr. Suarez, I hope he's gonna be all right. All right, Mr. Gary, I put you back there to calm down. To file 251579, People versus Daniel Gary. We did look for Miss Brown. She's not here in the courthouse.
She's in no, at the fish store.
Well, they did speak to her by telephone. She is not here. Her position is she thinks that some jail time would be appropriate and she wants to continue the no contact.
She was happy to hear
that's
from her.
presently in place.
She
All right,
wait
so
for it.
Daniel, can you
Party at the house.
tell me what you want me to know?
Yeah, man, the basement's a party room. She wants jail, but she just told me before we got here about probation was good. I mean, we got a reliable car. My mom finally co-signed after 4 cars that now she can DoorDash. She got a brand new car. That wasn't the problem anyways. That was the main fight. I mean, her car kept on breaking down, it was, $700 to $1,200 a month.
So your mom-
Also my mom co-signed for it.
Your mom got Ashley a car?
Yeah.
Or as of when?
What was it? About a month now. And, yes, I mean, so we had to depend on her. I mean, that was a big issue between us because she kept on breaking down. She went through 4 vehicles before my mom. Go sign.
Buying like $1,000 beaters and it just was not.
So you got her a decent car?
Yeah, ever since she got out of the center, me and my already had pre-planned to help, change people and places and things, just at least 2 hours away from here, sell a house and move. All you have to do is.
Well, you mentioned that before, that you'd maybe like to move south and Mr. George.
Or northern Michigan, because she wants to be close to her kids, That's the only problem. You just don't want the ex-husband, Joshua Brown, having that opportunity at least 2 hours away to come, because actually don't know not to say no. And he stays, and
All right, well,
for 3 days, he wants to stay forever.
You mentioned that you discussed this car with her like yesterday?
No, they got like a month ago.
Okay.
Yeah, because my mom just finally had wits end because Ashley was texting.
All right, so she got her a car.
Yeah, she
and
got
then
the car color, the color she wanted.
Since I saw you last, have you had contact with Ashley?
No, it's right for you. That's it.
All right, well, how did you know she was gonna be here today?
Well, because her and my mom, they got paperwork they got finished up to sell the house, you know? They had an appraisal, the guy come in sometime this afternoon,
All right,
actually.
her name is on the house?
Yeah. It's like a wedding gift, you know? What's about a year now, a little over a year now.
Who put her name on the house?
I
Right
did,
there, my mom owned it.
All right, so you put her name on the house because she was in a relationship with Daniel?
right.
We're ready to get married. I mean, we just wait for Joshua Brown to.
It's actually very good for Dan.
2 hours should be good enough.
Appreciate it more, he doesn't. Appreciate it as much as you should.
Yeah, she's loves doing that. She makes like what, $4,000 a month, you know?
I mean,
Crazy.
he's no longer using meth because of.
Can't wrong through wild business. But
Yeah, it was hard sometimes to determine methamphetamine from mental illness.
Right, so when he started
I get
using meth, that's
excited.
when it turned his brain to mush or whatever, because prior to that, he was okay. But
All right, again, we've just got voices from the gallery. That's Mr. Gary's mother, who is supportive of him and tried to be supportive of Miss Brown.
Hey, Judge.
Yes.
Because we're getting into we're talking about support. What's that? What were we talking about? You remember? Because it had to do with trying to look out for Ashley to succeed. She needs to change people's place to think. Born and raised right here. I mean, I don't know, but you know, I wanted this. It was a place I died. You know, this is my forever home. And she come into my life, and I know that I know. I mean, St. Joseph County probably knows Joshua Brown and everybody that's in between all that bullshit. You know, and I'm all about surprised. I'm man, but she's the last crush that she's born and raised here. She knows everybody, and she needs at least, and I agree, at least 2 hours away. I mean, it gives you a double thing to take off 2 hours. You know, and hopefully make the right decision, but. You know, it's a help because our kids, Josh and Aubrey, I'm trying to be mental with Josh. You know, he likes to fight and stuff. And for Christmas present, Ashley, I suggested all I did is we'll go right on for self-defense classes, or you know, karate. But he chose boxing and Sturgis. So he goes 3 times a week. Ashley got to take him 3 times a week from here to Sturgis.
Who's that, her son?
Yeah, her oldest son, and best Christmas present ever.
All
Is what
right,
we got.
I'm
I was
gonna,
just a suggestion.
I'm gonna do a fine of 0.
But yeah, give him a mentor and do right. Sorry.
$75 crime victims' rights fee, a $50 state minimum fee. I'm gonna waive the attorney fee. This was a assault charge reduced to disturbing the peace. The defendant has continued to have contact with her in violation of my direct order. I'm not gonna be able to stop it. Number 12 days jail credit 2, leaving 10 days to serve. We'll put that other on part of the plan. Mr. Gary, you're going to jail right now. You're gonna get good time. You're gonna get out in about 8 days.
Can we do like weekends there? I mean.
Yeah, there will be some weekends included in there, but you're gonna do it straight. You go with the officer.
And what? Just a couple days and.
Yeah, so I'm
everything
gonna
solved?
talk to Lauren at the,
What's that, sir?
I'm gonna talk to Lauren from Pivotal. Make sure you get your medication.
I really
but-
appreciate that. My mom will help you with that.
All right, but you were continuing to violate the condition, and I'm not sure this whole relationship is closely related. It was reduced from a domestic assault to disturbing the peace. He's gonna do 10 days, and I'm not gonna try to supervise this
Ashley's
probation.
at the free store now.
All right, he's obviously having contact. She's having contact. All right, he'll get probably 2 days of good time, so he's gonna be out about 8 days from now, which means he's gonna be in for Christmas. But everybody will have a little peace and quiet. All right, thank you. Are you Kristen Brandeis?
I am, yes, Brandis.
And are you Carly Friesen?
Yeah.
All right, I'm going to ask you, will you both please raise your right hand? That's your left hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Yeah.
All right, you just heard me dispose of 8 other cases, either by default or adjournment. Your case is actually a contested matter where there's 2 different versions of the story. You're in small claims court. Small claims is a separate division of the 3B district court where you can sue for up to $7,000. Neither party is allowed to have an attorney in small claims court. There's no formal record being made of the appeal, and there's no formal record being made of the proceedings, and there is no appeal. Any decision made here is final. Either party has the right to remove the matter from small claims to the general division of the court. But you have to tell me before we begin. Once we start, any decision here is final. Ms. Brandeis, you understand?
I do.
And Ms. Friesen, you understand?
Yes.
And are you both ready to proceed?
Yes.
Yeah.
All right. There was an accident at the Centerville High School parking lot, and that was on September 18th of 2025. Miss Brandeis contends that her car was hit by Miss Carly Danielle Swartz Friesen, and that she was leaving the scene, and they stopped, got her information. Defendant represented that she was covered by insurance, and it turns out she was not. So there are arguments that this is not covered by the no-fault statute because A, Ms. Friesen didn't have any insurance, and B, it happened in the parking lot of a school. And so Ms. Brandeis has supported or submitted evidence to show the amount of damages she received as a result of this accident. It doesn't take much. She has a quote from Chuck's Body Shop of Three Rivers. And that is the amount of $2,211.51. Parts, labor, taxes. That's the quote you have to repair your car. Is that correct?
Correct.
Have you actually had the work done?
I did. It was done, I believe, on October 22nd through the 24th.
So your automobile has been repaired and you're out this amount of money.
Correct. I paid out of pocket.
All right. Ms. Swartz Friesen, what's your response?
This whole thing was a bit of a mess. The parking at the school we weren't even parked in parking spaces. So I don't know if that was made clear on her end or even mine to be whatever. But so yeah, I was parked like everybody else, like a half circle, and she was parked more or less outstandingly, kind of behind me.
What event were you there for?
My daughter's cheer practice, and so we all kind of park on the grass in a half circle, kind of like a slant, at a slant. We're in the grass, and she was parked completely totally wrong from me at all. And so, yeah, when I went to back up, I backed right into her car. I didn't see it. Genuine accident. I had no idea that my insurance was not on my car. it was coming out of child support. So I don't use that account. I don't look at that account. It's not even something that I notice. So I had no idea that it was stopped. So when she had made the statement that I had given her false information, sure, that may be true. But I didn't know that. That was not my fault. Was
All right,
not
well, tell
aware.
me that you didn't know that your insurance had lapsed?
No, I had no idea. I hadn't gotten any
All
information
right.
about that.
All right, well, your insurance is paid automatically out of your child support?
Yes, it's auto pay.
So the child support goes into an account and then you auto pay out of that account to your insurance company?
Yeah.
All right, and at some point that didn't happen, so your insurance lapsed.
Yes, because child support is kind of up and down and backwards and all around.
You don't always get it.
Yeah. And like I do, but it's like smaller amounts or it's less than what it normally is sometimes. So that's the problem there. And I have also have no problem paying Kristen or whatever her name may be back. I have no problem doing that. But the issue that I have is she was kind of yelling at my wife at this game in front of children and mothers and grandparents alike. And that kind of set me off. It set obviously my wife off. That's not very professional. And then I didn't have Brandy's number. I didn't have her information. So when I reached her, she did not give me any information as to what her car was, how much her car was to fix. She let my wife know that. And didn't give any paperwork, gave no proof, gave nothing of that, just kind of demanded out of her mouth that we owe her $2,000. Okay, well, I'm going to want a little bit of proof. My car also has damage. I mean, my taillight, my bumper, I have her black paint smeared on my white car. So, there's damages on both ends. I understand hers is probably a little bit more severe. It was a whole door, whatever else it might have been. But yeah, I just, so when I reached Brandy's, when I did finally get a hold of her, I called her workplace because I had no other way to get a hold of her. And the first thing she told me was that this was extremely unprofessional and that I had no business, I guess, technically calling her like this. But then she seemed to calm down a little bit. I calmed down a little bit. We actually kind of seemed to talk. And it seemed like we were on what I thought was an understanding. And I messaged her my number to show her that I wasn't lying. I wasn't trying to hide anything, that this was genuinely me. She responds with thank you. And then I hear nothing. And then I get certified mail in the mail. And I'm like, okay, this is a little bit of a shocker. I didn't mind paying her. I just wanted a paper. I just wanted something stating that this was actually the cost of it. That's all I wanted. And
Well, that's not well, I'm going to give you that.
so that's really where I'm at. Like I said, I'm not trying to be unfair or unreasonable, but yeah, it was a two-way street. I mean, there was words that were being exchanged that didn't need to be. There was things that happened that shouldn't have happened on both ends. And yeah.
My son was in an accident once. He ran a stop sign and hit a lady. We were insured, so we were covered by mini tort. And she was so mad at him. He was about 22 maybe. And she just berated him at the site of the accident. Police officer told him to go stand somewhere else because she was so upset. We did pay her the mini tort amount. So tempers can rage. But the bottom line is this cost her $2,211.51 to repair her car. How much can you pay each month?
Well, I'm not 100% sure just because I do have wages being garnished already out of my check, due to something else. And also, I would like, if possible, the court fees to be covered by her or somebody else because I did try to come to an agreement with her. I did reach out to her. I did text her my number, my real number. I did try to communicate with her. I just needed a piece of paper stating that this is what I owed her. That's really all I needed.
All
I
right,
didn't
that's
need,
what this is.
so,
So I'm gonna give her court costs, but, Judge McManus used to make everything payable within 24 months. Judge McManus was judge here when you were about 3 years old. I took over 24 years ago, and he was the judge for 36 years before I got here. But he started the court, and he tried to divide everything essentially within at least 24 months. So I would expect that you would pay at least $100 per month regarding this. Are you able to do that?
that's fine. I can do that. Can I start that in January though? Because I
Yes,
am getting
January
my,
15th
that would be great. I appreciate it.
and the 15th of each month thereafter. Now, you
Sounds
can
good.
pay more if you want to just get this over with. You get a tax refund, or you sell a car, or you win the lottery or something. But as long as you pay $100 per month, she can't pursue a garnishment.
Okay. That's fair.
Ms. Brandes, are you still at Pondview Lane?
I am.
Is that the new subdivision off Ash Road?
It is near it, yes.
All right, and Ms. Friesen, you're still at Laura Court, Apartment D?
Yep.
All right. I'll send you each a copy of this judgment. You send $100 per month directly to her. I'd suggest you send it by certified check or money order. Again, if you want to get it done sooner, just pay it off with a tax refund or something. But as long as you pay that amount, she can't pursue any other collections. Ms. Brandes, do you have any questions?
If she doesn't send by certified check or money order and decides to send a personal check, let's say, and I don't feel comfortable cashing that, what are my options?
Well, if she sends you a personal check and you cash it, great. If it doesn't clear, then we've got other issues, including NSF check. But I would, before I reject it, I would at least attempt to cash it.
Okay.
All right, ladies, I hope everybody goes on from here. You probably won't see each other. You live in Three Rivers, she lives in Sturgis. I'm not sure what kind of cheer practice was going on in Centerville, but
Our children
it's
go to
not
school
like
together.
cross
So.
paths much anymore. All right, you're both free to go. Thank you.
Thank you, Your Honor. Merry Christmas.
Thank you.
Thank you.
And so we'll start with Mr. Walton. Which one is Mr. Walton? You come up and take a seat and right there. And then Mr. King is on the Zoom call.
Yes.
So Mr. Walton, could you raise your right hand, please?
Yes,
Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
How is it that you need an order against Mr. King?
So I've prepared a brief statement, if that would work.
Well, I've sworn you in. I need you to tell me however you want to do it.
Okay. Yes,
Most
sir.
people just tell me what happened out there. You're asking for an order against Mr. King.
Yes, sir.
Why is one necessary?
Okay.
Within the context of that definition that I read earlier.
Yes, and I've also submitted a statement of facts as part of my case file. So that's a very thorough and detailed write-up that has.
Okay, well, why don't you, we're on the record now
Okay.
in an open court and testimony. So why don't you put all that on the record? And then I'll swear in Mr. King. I'll hear his response.
Yes, sir. I'll start with the high level. My name is Michael Walton, and I am seeking a domestic violence protection order against Jason King. I'm a computer scientist in career transition and currently studying mycology and forest ecology at the Evergreen State College. I'm also a writer, naturalist, and outdoorsman. I characterize myself as a quiet, private person and generally keep to myself. I am seeking this order after enduring over a year of continued stalking and harassment perpetrated by Mr. King against me following the breakup of our 2-year relationship. Mr. King's jealous, impulsive, and personally invasive behavior presented challenges early in our relationship, and these continued patterns were a significant factor motivating our separation. I repeatedly told Jason while we were together that I was not comfortable with non-consensual or coerced monitoring of my whereabouts and would not tolerate invasions of my privacy. Over the past year, Mr. King's continued stalking behavior has had a deleterious effect on my mental health, damaged my personal relationships, and been disruptive to my career and academics. I've done my very best to tolerate Mr. King's erratic behavior in the hopes that he would eventually move on without further incident. I have held off taking any legal action as I have no desire to disrupt or negatively impact Mr. King's life. I continue to hold no ill will against him and want nothing from him other than to be left alone. However, it has been over a year now, and I have learned that Mr. King has been bothering my family, friends, and acquaintances. This behavior has caused additional emotional distress for myself and my relationships, and made it difficult for me to form connections at a particularly challenging part of my life as I navigate a breakup, moving to a new area, and a career transition simultaneously. I'm requesting a domestic violence protection order as I feel it is the safest, minimally impactful option to mitigate risk of further harm. I believe the court will agree that this order is necessary to guard against further stalking, harassment, and potential escalation from Mr. King. It is my sincere hope that Mr. King will understand the severity of the situation and take whatever steps he needs to heal and move on from these harmful patterns.
So in your recitation there, you just kind of refer generally as stalking and harassment.
Yes.
Specifically, what has he done that leads you to those conclusions? Because I can't just say, well, he's stalking me, so things like that. I need you specifically he's done.
Absolutely, sir. That's all recorded in my statement of facts.
Okay, go.
Okay. Michael Walton ended his relationship with Jason King on October 17th, 2024, after living together for approximately 2 years. Michael requested at that time that Jason not contact him outside of arranging times to pick up Michael's belongings, and that he not be present when Michael came to the residence. The two parties remained on speaking terms for several weeks, and Jason initially seemed to honor Michael's requests. In the afternoon of October 28th, 2024, Michael packed a number of his belongings from an office space he rented located at, and that's redacted in the document I submitted, but I have the address, of course. Jason was aware of this address of Michael's office and had occasionally visited the location during their relationship. After packing his belongings, Michael drove to Olympia. Around 9 p.m., Michael received an iOS safety notification indicating that an unknown Apple AirTag was traveling with him. Using the locate AirTag feature, Michael found the AirTag in an exterior cargo bag on the back of his vehicle. This device was placed there without Michael's knowledge or consent. The AirTag serial number, GPS, track, and owner information can be found in the attached evidence, with the last 4 digits of the owner's phone number matching Jason's. Michael deactivated and disposed of the AirTag and did not confront Jason about the incident. On November 10th, Michael arranged with Jason to remove the remainder of his belongings from the residence they shared, located at address. Arrived at 12 o'clock and did not see Jason there, although a number of Jason's friends were present setting up for a party. Michael packed his belongings, including a 3D printer, which belonged to him. Michael left the residence at 12:58, stopped at his office in Centralia at 1:30, and returned to his permanent address in Olympia. At 3:30 p.m., Michael again received several iOS safety notifications indicating there were several AirTags traveling with him. Michael found a total of 4 additional AirTags, 3 of which were hidden under the floor mats inside his vehicle, and 1 of which had been hidden inside of the control box of the 3D printer, which was previously in Jason's possession. Serial numbers, GPS tracks, and owner information for these AirTags can be found in the attached evidence. Again, the last 4 digits of the associated phone number match Jason's. Jason sent Michael a lengthy message on November 14th, 2024 at 1:10 p.m., indicating that he wanted Michael to retrieve a box of his belongings that he had left. Michael replied that he would respond later as he was in meetings all day. Michael sent a message at 10:17 that he did not want the items and suggested that they be donated or discarded and wished Jason the best. At around 10:30, approximately 15 minutes after sending this message, Jason pounded loudly on the door of Michael's residence. Michael had never told Jason his new address, and the visit was unwelcome and without Michael's consent. The time between Michael sending the message and Jason's arrival indicated that Jason was already in the area of Michael's residence, located approximately 30 minutes outside of Olympia and 1 hour from Jason's residence. In a raised voice, Jason aggressively demanded that Michael open the door. Michael did not comply and repeatedly said through the door, "Get back in your car and drive away." Jason continued to demand that Michael open the door and screamed that he was having sex with an individual that Michael had recently become friends with. Finally, Jason got in his car and drove away while honking the horn of his vehicle. After this incident, Michael blocked Jason on all platforms. In the weeks and months following, Michael received a number of packages and letters from Jason, some hand-delivered and others mailed. Jason also subscribed Michael's new address to a book delivery service he did not consent to. Jason sent Michael a text message on March 10th, 2025 from a second phone number. All of these actions were undesired by Michael. During the spring and summer months, it was indicated to Michael by several friends that a strange account had contacted them via dating platforms. In some instances, this account claimed to be Michael's significant other. The unknown account knew personal information about Michael and asked probing questions as to Michael's whereabouts and the nature of Michael's relationships. Michael's friends expressed that they do not feel comfortable sharing further details for fear of retaliation by Jason. Michael encountered Jason unexpectedly in Olympia Target towards the end of September. The two were relatively cordial. Jason indicated that he had a package Michael might want. Michael exited the conversation as politely and quickly as he could. On September 28th, Michael met and became friends with a redacted party, hereafter referred to as the third party to protect his privacy. It was later observed by the third party that Jason messaged him unexpectedly about an hour after having met Michael. The third party further noted that it was odd that Jason was asking him questions about a white Jeep, which matches the description of Michael's vehicle. Further details can be found in the third party statement as attached evidence. On December 10th, 2025, at approximately 2:30, Michael visited the third party at his home at his address. The third party seemed nervous and asked if Michael could park his car in another location behind a barn so that it would be out of sight of the road. Michael inquired as to why, and the third party indicated that Jason had been there earlier that day and was asking very strange questions about Michael. The third party also indicated that Jason had shown him intimate videos of Michael on his phone. The third party then indicated that Jason had been trying to convince him to let him come back to the house and had driven several times up and down the street. Michael asked the third party if he would feel safe if he left, to which the third party responded in the affirmative. On departing, Michael then observed and photographed Jason's car parked in a driveway within walking distance of the third party's residence. A photograph of Jason's vehicle with license plate at that location are provided in the included evidence. After this incident, Michael contacted Thurston County Police and spoke with Deputy Warnock to report the series of incidents involving Jason King that had occurred over the past year. The officer's notes for this police event are provided in the attached evidence obtained via public records request. After reviewing the timeline of events, Michael became convinced that his location was still being tracked and inspected his vehicle again for any signs of tracking devices. At 2:20 p.m. on December 17th, 2025, Michael found a GPS tracking device inside a weatherproof case magnetically affixed to the rear underside of his vehicle. Photographic documentation of this device is provided in the attached evidence. This incident was also reported to Thurston County Police and described in Deputy Forda's notes for the police event number provided in the attached evidence and obtained by a public records request. Michael, again, does not want anything from Jason other than to be left alone. Michael is concerned that Jason's behavior now affects more than just him, as Michael's friends and relationships have been targeted as well. Michael has only resorted to involving the court to request this protection order as he believes it is the safest solution for all parties involved.
When was that, those Apple tracking devices, for lack of a better term, that was back when the relationship broke up, but the most recent one, when was that discovered?
I found that December 17th, so that was last week. And the event involving my friend, who I refer to as third party, that occurred on December 10th, and I did confirm that Jason's vehicle was parked just down the street.
Give me just a minute. Mr. King, could you raise your right hand, please? Do you swear to affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth? Well, you're muted, so I can't hear a thing you're saying, first of all.
Apologies, I'm in a hotel and the cleaning person walked in right as you're saying that. But yes, I do.
Okay, so again, raise your hand then, please. You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. What's your position on Mr. Walton's request for an order?
I have some things I'd like to go over as well. First I want to say whether a restraining order is done or not done, it's very clear now to me that there is no moving forward in any capacity of a friendship or anything like that. So either way, I don't plan on having any contact with him at all. But I do want to touch on some things that were mentioned. First of all, on December 10th, the person, his name is Angel. I actually have text showing that he invited me over. I was there, and that he also, I'll just read it to you. And I don't know if you want me to read everything, even the.
I mean, that's not really. I'll be blunt with you. You know, Mr. King is making some.
Well,
that's really the fact that you were there is not great. But I mean, there's other things that are more important that I've heard. Let me put it that way.
Okay.
So it's up to you as to what you want to tell me.
I was I was just starting with that, if that's okay.
But you can just generalize what you're what you want to say, but go ahead. I'll hear from you.
Sure. Okay. On December 10th, 11:30 a.m., the person that we are both talking about, his name is Angel. He messaged me. He said, hello. He said, are you available right now? I'm alone right now. No people here. I said, I just sat down to eat. I can come over after. How long are you available? He said 4 hours. I said, what's your address again? Heading over. This was at 11:49 a.m. He gave me the address, asked my ETA. I said 20 minutes. He says, park your car in the same spot, not in the driveway because it belongs to the renters. I said, okay. Went over, saw him, left. And then at 12:59 p.m., I messaged him. I said, I think I left my other set of keys there. He goes, okay, you can come. I said, okay. I went over at 2:31 p.m. and there was the white Jeep in the driveway. So I parked down where he had told me to park, and I was waiting for the white Jeep to leave to go because from the looks of it, it was Mike's Jeep, but I did not know that Mike was there until I drove by. It was stated somewhere that I had drove by several times. I only drove by once and then parked. That was that.
Okay, go ahead. Continue on.
Okay.
What you'd like to say?
Sure. Going back, I just wanted to kind of give a brief summary of during our relationship. There were several times that Michael had talked about being bipolar, and this will all kind of make sense as I get to the end. On June of 2022, I had found out that he was dating someone else and traveling with them without my knowledge. We sat down at an airport and talked about this and about his mental health and him doing the correct thing and talking to this person. And he did. That was a first episode of that. On October 9th, 2022, my brother, who Michael had became very close to, had ALS, and he passed away. And Michael was the one that found him. And I know that was very difficult for him, and that didn't help his mental health. And I tried to be there for him. October, it was the 29th or 30th of 2022. We were in Nashville. We went to a bar.
I don't need to. I'm concerned also with recent things, and maybe I could have said the same thing for Mr. Walton about things in 2024. Things that happened in 2022 are going to have no bearing on what I do here today.
Okay.
And so I just want to let you know that that's not really relevant to the.
The only reason I was talking about it is because in the end, the reason there was many instances over the time that we were together that he would have episodes or fall into depression. and it would concern me throughout our relationship. So long story short, in the end, after we broke up, at first I thought that maybe this was another episode because had happened several times like this. And I was concerned about him. So I did one day, he had came to the house to gather his stuff, and I followed him up to his new place, and that is how I found out where he lived. It wasn't through air tags or tracking device or whatever. And as far as that book club thing, I had already done that through a relationship, and just continued it on as like a Christmas gift, because that was at the beginning of our breakup, and I didn't. At no point has he ever, until this came out, said, don't contact me, don't I don't want to talk to you, anything like that. He, even on November 8th of this year, November 8th of 2024, after he, according to the documentation, found air tags and stuff, he asked me to go to lunch. He said that he had time to get settled, and he thought it'd be nice to have lunch and to catch up. One thing about the tracking, it was Michael's idea. We were in Greece together and during a relationship, and we were at the airport, and he was going to be gone. He was going to Mongolia and I think Italy after that. He is the one that suggested that we share locations on our phone, and we did.
When did he suggest that?
We were in Greece. When were we in Greece? It was like 2023, I believe. I could look up the exact.
Don't you think that suggestion might go away once you've broken up?
Well, we still shared our location after the day we broke up. It wasn't until, I don't know.
It doesn't sound like he really knew about that until he found these things on his car or in other places.
No, I'm talking about on our phone. Our phone location.
I'm talking about right now. I'm talking about the tracking devices that were discovered by him.
The tracking, the air tags, it was his sister who suggested that we get air tags for the dogs because they kept leaving the property. So yes, very well, there could have been air tags in his car left there.
And what about the one?
That one,
the most recently discovered one, which is not an air tag.
That one, I don't remember that. I did just look a few minutes ago at that picture. I don't remember that specific, but it very well could be while we were together that was in his car. Yes. But
so he was driving around about it with 2 years and not know about it?
That was something that wasn't recent. No.
Okay.
If it was put in.
Go ahead. I'll let you finish. Go ahead. I apologize for interrupting.
No, that's okay. Basically, and then we did see each other at Target in, I believe it was at the beginning of October. That was the first time we'd seen each other in person since we had broken up. And I take that back. Let me go back to the day that I went to his place to drop off the stuff. I had drove in. I knocked on the door. You could see from the ground where the windows that he was of his place. I saw him go grab a gun, which looked like a rifle, come to the door, and we did chat through the door. He did not open the door, and I did drive off and honk the horn because that one was kind of scary, and it also brought me back to like all these different episodes that he had, and I was concerned, and I was also scared for myself because he had pulled a gun. I don't think that he would have done anything. He didn't do anything, but.
And when did this happen?
That was on November 10th, I believe. 1 second here. I'll tell you exactly. Of 2020, we're talking about 2024, sorry.
Yeah, okay, again, I'm not. Okay, but I'll let you finish. But again, you need to understand that what I'm interested in are the recent activity.
Well, that was after we broke up. I don't know if that's what you're considering recent, or like, we're talking about like basically last year since we broke up. Is that correct?
Okay, yeah, you can continue.
Okay. That was on November 14th, approximately what he had talked about earlier of me being in the area and coming to the place that ties in with that specific incident. And then, but again, and yes, he is correct. I did leave like a Christmas packages. I left birthday package, and I did text a few times. But again, at that point, like, it was never stated, leave me alone. I don't want anything to do with you, anything like that. So if he would have just simply communicated and said, leave me alone. I mean, he'd asked me to go to lunch with him. We saw each other just back in this October of 2025, where we did have a cordial conversation. He even said he would reach out to me, because I did say there was a book, which is still at my place, that had came in the mail for him. So I guess what I'm trying to say is, if he would have just said, I don't want anything else to do with you, leave me alone, instead of being cordial, being not, you know what I mean? That's fine. I would have done it.
Well, here's where I'm at here, Mr. Walton and Mr. King. You know, I've listened to you both. I've reviewed everything that was filed before I came on the bench here. And, you know, I'll cut to the chase first, and then I'll explain why. I am going to enter an order. An order is going to be in place for a year. It's the parameters of the order are you're not to contact Mr. Walton, you're not to cause him any harm. And maybe most importantly, do not engage in stalking behavior of any sort. Don't come within 1,000 feet of him, his residence, or workplace. And the basis for the order, frankly, is the thing that most concerns me about post-breakup of these tracking devices. It doesn't make much sense to me that you would say, well, this is something we agreed to, when Mr. Walton is saying he's found them under his, you know, and he's getting these alerts, which apparently he hadn't gotten before, that those Apple devices are being replaced. And had that happened just a year ago and nothing happened since then, you know, I might not be that sympathetic to an order. But when I find that now that there's a different type of tracking device that he just recently discovered, and who knows how long it's been there, I can, but then to me, that would be disturbing to anyone. Have an ex-partner or someone you've been in a dating relationship with to find out that there's electronic tracking going on in a car, that's disturbing for anyone. And you said, well, had he just said that he didn't want any contact, none of this would have happened. No one needs to say that, hey, don't put a tracking device on my car. You know, that's almost the definition of stalking almost. And so that, frankly, is what concerns me the most, and why the primary basis for me entering an order. And like I say, and again, hopefully this draws up, you said before that whether an order is entered or not, you know, you're not really interested in having any contact with Mr. Walton. You know, again, I hope this just establishes a bright line so there's no question about, is this okay? Is this not okay? None of it's okay. He's just not a part of your life going forward. Do you understand that, sir?
Yes.
Okay.
Yes,
And so I'm gonna sign the order. Since you're here, I'll give you a copy of it now. A copy of it will get emailed to you.
Okay.
Did you have a question?
Yeah, if I may, Your Honor. So there were a couple sections that I had requested initially, and they weren't reflected in the document that I was served. So
What orders, what questions?
So it was under general restraints, section D, protected person school. As I mentioned, I am enrolled.
Oh, you're enrolled, and I thought, were you
Evergreen.
teaching? I thought I heard you were teaching.
I'm taking classes.
Okay.
Yeah. So a protected person.
And
school.
then are you associated with, and this is at Evergreen?
Yes.
Are you associated with Evergreen at all?
Me, no.
Okay, then you're not to go be at, that's included in the restraining order. Then you're not to come within 1,000 feet of Mr. Walton's school. Anything else?
Yes. Section F, intimate images. As I mentioned, I have reason to believe that Jason has intimate images of me and may have shown them to other people. I would like section F included as well.
I'll check that box also based on what's in the petition and the testimony. So you're not to do that either. Do you understand that,
I don't
Mr.
have
King?
any- Yes, I understand.
Anything?
That's fine. I don't have any images. I've actually gotten a new.
Okay,
phone
again, just
recently.
all I need from you is I understand and it won't happen.
Yes.
Go ahead, Mr. Walton.
And then section M, restrict use of litigation. I am concerned about retaliation from Mr. King. So I would prefer that that be included as well.
You know, I'm not going to do that preemptively. And if something happens that, I'll let, if he does pursue some sort of legal action, you can bring this up with whatever judicial officer at that time, and then they'll make that determination whether or not that's abusive or not.
Understood. Thank you, Your Honor.
Sure. Anything further?
That's fine. That's all.
Yes, Mr. King, do you want to say something?
I'm curious, what do you mean by legal action or?
I don't know, and that's why I didn't check that box. And so that box isn't checked. He's asking for so I don't know what's going to happen or what could happen. And that's why I'm not going to preemptively make a judgment on that.
Can I ask this just so I'm clear on everything, because I've never had this happen.
Say that again. I missed that.
I said, can I ask just so I'm clear on everything, because I've never had a restraining order, so I've not been through it before. What exactly, because we obviously do live like in the same similar area. Like, let's say I'm at a restaurant eating, or I'm at a grocery store or whatever, and not on purpose, but he shows up. Like, what happens? What do I do or he do? Like, how does it work?
The person who's under the order is you.
Okay.
And so if you go to a place and he's there, you need to leave. And then if, at the same time, I don't want this used offensively either. If you know that he's at place, you can go in there to force him out. That's not, he's under the court order, but if you go to a place and you happen to see him, probably be a good idea to eat or go someplace else.
Okay.
But you're the one, if you ever found in the same restaurant there, Mr. King, you're the one who's going to be in trouble, and you need to understand that.
So basically, like, if I'm in middle of dinner and he shows up, I mean, that hasn't happened.
Hopefully then if he would see you, then he would just go eat someplace else.
Oh, okay, got it.
And he's nodding.
Yeah.
What's that?
You're right.
He's nodding agreement.
Okay.
That'll conclude the hearing. A copy of this did you just get emailed to him? Or you can get this off the Thurston County District Court website, Mr. King. You, sir, can come and give it right here.
May I ask one more question? How does
this
affect me as far as like work or?
I don't know the answer to that. I have no idea.
Okay, got it.
In some fields it has an effect, in some fields it doesn't. I'm just making this decision based on what's in front of me here.
Okay, sounds good. Thank you.
And frankly, I don't know, and I'm not asking. I don't know what you do or anything like that. But anyway, you can get a copy of the order off the website. Mr. Walton, come on up and grab that, and you're free to go. And you're free to leave the Zoom call there, Mr. King.
Thank you. Have a good day.
Thank you. Mr. Devaney, why don't you come on up? And then Ms. Forney can come on the Zoom call. Ms. Palmer, I'll have you mute up. So Ms. Forney, can you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. And then how is it you need an order against Mr. Devaney?
So Nathan and I broke up in September, and we tried to remain friends after that. In October, I had asked him for some space, and he continued contacting me, numerous text messages, until I finally ended up blocking him on October 21st. After I blocked his phone, he started contacting me on Facebook and Instagram, WhatsApp, and Google Meet, which I wasn't even aware was a thing. Emails, voicemails, he would not stop. He threatened suicide numerous times, saying that it was my fault that he was going to die. And all I wanted was space. I had asked him very clearly, please stop contacting me. I don't wish to continue having a relationship with you. I am not looking to be friends. I just want peace. So between October, the last time I had contacted him was October 21st when I had blocked him. And then I continued to get emails and voicemails. And one of the emails said that if I would just meet with him face to face and tell him that I didn't want to continue having a relationship with him, then he would leave me alone. So I took that as an opportunity and said that I emailed him back and said, I don't owe you a face-to-face meeting. I've already asked that you stop contacting me. I don't want a relationship with you. And that sent him into a spiral again. That I sent that email on December 9th, and it sent him into a spiral again that night, and that continued into the morning.
What do you mean by spiral? Describe that briefly.
Like 17 emails at least. He was blocking his phone number so that it showed up on my phone as a private number over and over again. I think I've got 8 voicemails from that night between like 10 p.m. and 5 a.m. One of the voicemails said that he had taken 24 a leave and was going to take 24 more. He's allergic to naproxen. He sent me pictures of in the email about of his face swollen, and saying all this was my fault, and he was going to die because of me. And I just want peace.
Okay. Let me hear from Mr. Devaney. Am I saying your name correctly, first of all? Could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You can put your hand down. And what's your position on her request for an order?
I'm not really trying to try and fight it. Everything she said about the electronic communications were true. There were a couple things in the packet that I saw that she had checked about stalking. I never once stalked her,
okay,
but I'm not refuting the electronic communications or the threats of suicide. I did do those, Your Honor. I have no ill will towards her. I mean her no harm. I'm trying to move on with my life. I've been suffering from a lot of mental and emotional health issues lately.
Are you seeing anybody about those things?
Recently did start seeing a therapist. Yeah, I just had my 3rd session.
Okay, good.
Last Friday.
And then you're here, you just a friend in support of you. Okay. Well, I'm glad to hear that.
Yeah, I've never had this happen before, so I didn't even know if I needed to show up. So I'm here just stating the case.
I'm glad you did. A lot of people don't. You saw just a minute ago when the person who chose not to be here, so an order was entered, and had you not been here, an order would be entered. Based on what's been, I appreciate what you're telling me. I'm happy to hear that you're seeing somebody to deal with all this. I am going to enter an order just because I don't think there's too much of it. Sounds like you understand why this might be disturbing for Ms. Forney to hear all this. And so, hopefully this just, again, provides a bright line. She's just not a part of your life going forward. And hopefully that'll leave you free to address the issues that you have identified for yourself that you need to see. I'm glad to hear that you're seeing somebody. I hope you get that worked out. And but let's just eliminate Ms. Forney as an issue you need to deal with. You need to deal with, you have your own things to deal with. All right. Give me just a moment and then we'll give you a copy of that. And again, this order will be in place for 1 year. Again, you're not to cause her any harm. Don't contact her. Don't engage in stalking behavior. I heard what you said, that you haven't done that, but nonetheless, that'll just be part of the order. Don't come within 1,000 feet of her residence or place of employment. And we'll, since you're here, we'll make a copy of that, send that to you. Ma'am, we'll send a copy of this to you, email a copy of it to her. You'll get a copy of this to email, all right?
Thank you.
Good luck to you both. But again, she's just not a part of your life going forward. We'll make a copy of it and give that to you. Once you get that, you're free to go. And like I say, ma'am, you'll get a copy of that in a minute. Good luck. Good luck to you, ma'am. You're free to go. A copy of the order will get sent to you. And one last time, it'll be in place for 1 year.
Okay, thank you.
You're welcome. And Ms. Palmer and Mr. Miles can come on the Zoom call, please. So Ms. Palmer, could you raise your right hand, please? You swear and affirm the information you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
How is it you need an order against Mr. Miles?
Mr. Miles and I dated very briefly back in October of 2025. And I very quickly realized that this just wasn't going to work out for us. He was very manipulative when it came to sex and touching, and I just wasn't comfortable with that. And I expressed my boundaries to him multiple times throughout our very short relationship, and he continued to ignore those. So we broke up. We tried to remain friends while he went off dating.
Can you hear me?
Yes.
Okay. Your petition says you dated back in the summer of 2018.
Yes, we did. And then we broke up. We broke up, and then we started dating again in 2025.
In 2025. Okay. Sorry. Go ahead. You can continue.
And I'm sorry, I lost my train of thought. We decided to be just friends, strictly friends. And I woke up for work one morning and found all of my debit cards cut up. And I had asked him about this. He said, "Oh, I don't know what happened." So I just kind of, I brushed it off, which was really silly of me. And then I'm currently staying with family friends, and he kind of moved in, kind of didn't move in, but he was staying with us, and the family friend did not want him there for more than one night, but he kind of made himself, a presence there. I'm seeking a restraining order because I generally feel unsafe around Mr. Miles. He has caused me a great amount of emotional distress. I am very nervous when it comes to leaving my workplace, when it comes to leaving the house, when it comes to just going out within town. I'm very nervous that I'm going to see him.
I'm going to say, he came to your residence. And you
Yes.
guys are the worst people I've ever met.
Yes.
Pray to your false gods before I take control. And then he proceeded to punch himself?
Yes,
Tell me
he
about
punched himself
that.
in the mouth repeatedly and spit blood in his aunt's face.
So are you living with his aunt?
Yes, and they are in agreement with the restraining order.
And so does he still live there?
No.
Okay. Mr. Miles, could you unmute, first of all?
Yeah.
Could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
What's your response to Ms. Palmer's request for she just basically want an anti-harassment order that keeps you away from her?
I have no problem with that. A lot of this documentation, there's lies in it. The statement about that you were just reading and me punching myself in the face multiple times, No, what happened was my uncle went to throw a punch at me. And yes, I hit myself in the mouth because I covered up because I wasn't trying to get punched in the mouth. And then it says that I said that I turned to Miss Palmer right after that and told her that you're lucky that you work where you do, otherwise you'd be there in a blink of an eye, which that happened October, what was it, November 24th, which was in the afternoon, which Miss Palmer was at work when this happened. So she wasn't even there to say that all of this happened and say that I said that, turned to her and said that to her face when she was never there. The
Well,
debit card.
but you said it to her.
No, I never said that to her. She was never at the house when that situation ever occurred. She's taking what my aunt is saying happened and wrote it down as she was there when she was never there. And she was at work, so she's clocked in at work. So it's proved that she wasn't there.
Where do you work, ma'am?
I work at Telecare Thurston Mason.
And then did he say that to you? You'd be lucky to work where you do, otherwise.
Yes.
Did you hear him say that?
Yes, I did.
Right after I spit in Linda's face.
And were you there when again, Mr. Miles, don't interrupt, please. I'll give you a chance. He's saying that you weren't there when this whole punching in the mouth incident took place?
I was there.
All right. Go ahead there, Mr. Miles. I'll give you the final word here.
Your Honor, I can send you text messages where I sent messages to my current wife and talked to my current wife about the situation that happened around 4 o'clock in the evening, where I was working, so I could show you where I got off work and where she was at work till 7:30 at night.
So it sounds like you guys have known each other for a long time. If you dated in 2018 and now.
Well, we really didn't date. We hung out for a few days, and I was talking to another girl, and I told her that I did not want to pursue a relationship with her, that I wanted to pursue a relationship with this other girl. And
was this 2018 or 2025?
2025.
Okay. And then I thought I heard you just say you're married?
Yes, I was in the middle. Me and my wife broke up, and we were gonna get a divorce. And I ended up going over to my aunt's house and staying there. Nobody told me that I could only stay one night. I was told this when they were kicking me out. I have no problem staying away from Miss Palmer. Okay. I've only seen her a few times throughout the years. And I've seen her like 5 or 6 times over the years, but I've never said nothing. I've seen her one time about 6-7 months ago at Planet Fitness, said hi, and then in October. I have no problem not talking, going anywhere around any of that. My aunt, my uncle. I'm just cutting that out of my life.
Okay.
I had a lot of bad influences in my life, and everything that I've cut out of my life. And so I have no desire to be anywhere near, around, talk to, or anything of Miss Palmer or anything of that nature. So the order is not really needed, because I have no problem staying away from her, because I don't want to be associated with lies like that.
And so, Ms. Palmer, I guess I'll give you the final word here then. What's your take on what he just told me?
I still would like the protection order to be in place for my own safety. I have no desire to be around Mr. Miles. I want no association with him in any way, shape, or form. But for my own safety, I would like a protection order to give me peace of mind.
So based on the testimony combined with what's in the petition, and I kind of hear an agreement from you there, Mr. Miles, an order will be it'll be in place for 1 year. And again, it's just create a bright line where you know where you're at, Mr. Miles. You're not to contact her or where she's living, and if she's living with your aunt and uncle, you're not to go there, which also sounds like a great idea if there's physical confrontations between the two of you, regardless of who's at fault. And so that order will be in place for 1 year.
What limitations does that put on me for anything?
Just don't cause any harm. Don't cause any harm. Don't contact her. Don't engage in stalking behavior. Don't come 1,000 feet of her residence or place of employment. That's it.
Easy peasy.
All right. That's, I hope so. I hope so.
Thank you, Your Honor. Can I have this emailed to me, please?
Yes. And Mr. Comer, Miles, you can get a copy of it off the district court website.
All right.
Thank you, Your Honor.
You both are free to go.
Yep.
And that is it for today here at the court gallery, ladies and gentlemen. But stay tuned. Do not go anywhere. Do not change your channels, because there is a redirect. There is a redirect. There is more court content coming up right now. We're headed over to Hitch Hutch. We're going someplace else. We are. I promise we are. And I'm going to share that link right here, right now, for everybody to see. Ladies and gentlemen, thank you so much for hanging out. I want to get the little camera out and wave at everybody and say thank you so very much for coming and hanging out with me tonight. These are the court cases that I found that really, I'm gonna give everybody a hint how I choose my court cases. I'll be watching the court cases, and something in the case will make me turn my head. It'll perk my ears up, and I'll say, there's something in that. There's just something, there's a lesson here to be learned. Something that we can all watch and listen to and understand that, man, just don't be like that. Just ain't right. Ladies and gentlemen, I am your Lone Wolf Usul. I am your humble curator for these here videos on this here channel. I am your humble host for this here live stream every single night of the week, starting at 8 p.m. Central Time. That's 9 p.m. Eastern Time. Come on by, participate in the live chat, hang out with us live every single night, and on the weekends on Saturday at 11 a.m. Central Time. That's noon Eastern Time. Come on by and say hi to us. Ladies and gentlemen, thank you very much for hanging out tonight, and go tell Hutch hello. He's got some great soft sit action going on. Ladies and gentlemen, have a great night. I'm your Lone Wolf, and I am out. Bye now.